for the SEMER Institute, and I wanted to welcome you to our webinar today, which is titled The Challenges of Serving Undocumented and Immigrant Families, a Guide for Case Managers at the SEMER Institute. I'm happy to say that this is being provided in partnership with the Sargent Shriver National Center on Poverty Law. You know, setting up a webinar in the middle of the day like this is an opportunity, but we're excited that we already have over 100 individuals that have signed on and potentially up to 150 registrants today. So I want to thank you for taking time out of your day to be a part of this. I think you're going to be very excited about the content of information. A little bit about the purpose. We really heard from our partner communities over the past 6 to 9 months during our monitoring calls that this would really be a topic that would be something of interest to you. We have several partner communities and their service providers that are struggling with undocumented and immigrant families, and we wanted to be able to respond to your requests with this capacity building opportunity. So a little bit of logistical things. Anybody who registered for the call today should have received the PowerPoint that we're going to go through via email. If you're sharing a computer or if you have other individuals within your group that didn't register but might be on the call, feel free to share that information with them. Throughout the webinar today, you're going to have the opportunity of submitting questions, and those questions will be monitored and answered throughout the presentation. What I would like to ask though is we would allow our SIFS partners and service providers really to kind of take the lead with specific questions that you might have related to the participants within your targeted population. We're also going to be able to have a chance for some polling. So when we get to that point, the presenters are going to pause for a moment and let you poll to answer some of their questions. I think you're going to find this interaction very beneficial. I do want to acknowledge that there is a lot of information that's going to be covered. This webinar is being taped. It's going to be provided on YouTube. So if you miss something, want to re-listen to it, or provide it to somebody else, after everything is all said and done, we will send out that information to everybody who has registered. So now at this point, I want to hand it over to the two ladies who are going to take care and walk us through this critical topic, Stephanie and Stephanie.
Thank you, Rob, and hello, everyone. This is Stephanie Becker talking, and I will be joined momentarily with my colleague, Stephanie Altman. We are both at the Sargent Shriver National Center on Poverty Law, and we're really happy to be here today to present to you on immigration and some of your issues working with immigrant families and undocumented families. First, a bit of an overview for the webinar today. This is our agenda, and it is packed full, but as Rob said, we will have time for questions. First, we'll give an overview of immigrant categories that drive eligibility for certain public programs. Then we will discuss specific eligibility criteria for public benefit programs, such as healthcare programs like Medicaid and Medicare, and then we'll dive into non-healthcare programs such as TANF, SNAP, which is food stamps, housing assistance, energy assistance, and other programs. Then we'll pause for a few questions, and we'll continue to discuss resources for undocumented non-citizens and the impact that accessing public benefits has or does not have on someone's immigration status. Lastly, we'll go over some resources that might be helpful to you, and then we'll go into a longer question and answer period. Stephanie and I will switch off presenting so you don't get too bored of either of our voices, hopefully. And as Rob said, throughout the webinar, please feel free to post your questions in the chat box, and we can get to them either during the presentation, or if we can't answer them right away or we don't know the answer, we might have to look something up, we will provide you with written answers after the presentation. So without further ado, first a bit of introduction to set the stage for the presentation. So the foreign-born population of the United States has grown quickly over the past several decades, increasing from 20 million in 1990 to 40 million, or about 13% of the U.S. population in 2010. Further, about 17 million children in the country have at least one foreign-born parent, and of these, a little over 2 million are themselves foreign-born. That is, nearly 87% of children with foreign-born parents are themselves U.S.-born citizens. In terms of demographics, immigrant families are disproportionately likely to have low incomes. About 23% of children living with at least one foreign-born parent have incomes below the poverty level, compared with 16% of children living with only U.S. native parents. A full 37% of children with only immigrant parents live below the poverty level, so which is why this access to public benefits is really important. So several federal programs provide assistance to low-income U.S. families, most notably Medicaid, the Children's Health Insurance Program, or CHIP, the Supplemental Nutrition Assistance Program, or SNAP, and Temporary Assistance for Needy Families, or TANF. Evidence demonstrates that these programs reduce hardship, increase family stability, and contribute to better health and nutrition for children. Immigrant families may be particularly likely to meet income eligibility criteria for these programs, but for various reasons, which many of you might have seen firsthand, for example, they think they're not eligible or they're afraid of applying, they are less likely than other families to access these benefits. So current federal eligibility for benefits was largely set back in 1996 by the Personal Responsibility and Work Opportunity Reconciliation Act. It's a mouthful, or PERORA is the acronym used, but it's also just often referred to as welfare reform. This law set limits on how states could use federal funding to provide benefits to different categories of immigrants based on immigration status, age, year of entry to the United States, and length of residence in the country. As a first step in determining benefits eligibility, PERORA divided immigrants into two main categories of benefits eligibility: qualified and non-qualified. And contrary to what these names suggest, the law actually excluded most people in both groups from eligibility from many benefits, with a few exceptions, and we're going to go over that right now. So the qualified immigrant category includes lawfully permanent residents, or LPRs, people with green cards that they're commonly called today. LPRs are people who are lawfully admitted to live permanently in the U.S. by either qualifying for immigrant visas abroad or adjusting to permanent resident status in the U.S. Many, but not all, our LPRs are sponsored, in other words, brought to the U.S. by close family members or employers. An LPR may apply for naturalization after living in the U.S. for 5 years in most cases. The second main category of qualified immigrants are persons fleeing persecution. Examples of this category include refugees who, while outside the U.S., were granted permission to enter and reside in the U.S. because they have a well-founded fear of persecution in their home country. Then there are asylees, who are people who are already in the U.S. who fear persecution in their home country, and they also satisfy the requirements for refugee status. Refugees and asylees are eligible to apply for permanent residency after 1 year. There are also other categories listed on this side of people whose life would be threatened if they return to their home country. For example, people who are granted withholding of deportation. And oftentimes, I should mention that people may or may not know exactly their status, their immigration status. So oftentimes this is listed on their immigration card. But other humanitarian qualified immigrants are entrants from Cuba and Haiti, and individuals who are paroled into the U.S., for example, for medical reasons, for at least a year. Qualified immigrants also include certain abused immigrants, their children and or their parents, and also certain victims of human trafficking. The Welfare Reform Act also set additional limits on eligibility for certain qualified immigrants. So we're just talking about that qualified group right now. Most importantly, qualified immigrants who arrived to the United States after 1996 have limited eligibility for federally funded public benefits during their first 5 years of qualified status. You may have heard of this before. This 5-year waiting period is often called the 5-year bar or 5-year ban. Qualified immigrants are generally eligible for federally funded programs only after their first 5 years of qualified status. And even then, they are eligible for TANF, Medicaid, and CHIP, which we'll talk about later, only if they live in a state that has decided to provide these federally funded benefits to immigrants. In other words, the welfare reform law restricted eligibility for many qualified immigrants by arbitrarily distinguishing between those who entered the U.S. before or on or after the date the law was enacted in 1996. On the right-hand side of your slide, you'll see that there are some notable exemptions from that 5-year ban or waiting period. And those are people here for humanitarians, such as refugees, asylees, veterans, members of the military on active duty and their spouses. LPRs are adults who have worked at least 40 qualifying quarters, as defined by the Social Security Act, are eligible for SNAP without that 5-year bar. And also LPRs who are under 18, so children, are eligible for SNAP only without waiting that 5-year period. Now let's turn to the non-qualified immigrant status. So non-qualified immigrants are immigrants who do not fall under the qualified immigrant groups, including immigrants formerly considered permanently residing under color of law, or PRUCALs they were called before, persons with temporary protected status, asylum applicants, other lawfully present immigrants such as students and tourists who are here on visas, and unauthorized or undocumented immigrants. So just to be clear, non-qualified is not synonymous with undocumented status. So in summary, the group of non-qualified immigrants for public benefit eligibility combines a variety of immigration categories, including people who are lawfully present immigrants, such as tourists and students, immigrants in protected statuses, and unauthorized or undocumented immigrants. It is estimated that there are about 11.2 million undocumented immigrants in the United States. In addition, about 4 million U.S.-born citizen children have at least one undocumented parent. And these mixed status families account for almost half of all the families with undocumented adults. We wanted to make sure to note that the term undocumented is not an official immigration category. It generally refers to someone who does not have legal status to reside in the U.S. It's important to note, however, that the specific definition of undocumented varies across laws and policies, and the specific mechanisms of inclusion or exclusion of undocumented individuals varies by laws or policy. Let me give you an example. Exclusionary policies generally do not use the word undocumented or even immigrant, but by virtue of not being listed as an eligible, undocumented immigrants are legally excluded. In contrast, many policies that include undocumented immigrants explicitly state that those lacking lawful status are included, or proxy classifications are used, such as individuals who do not have a social security number. So it's a very confusing and complex subject, we realize, and so we're glad we're here today to help maybe explain some of it. So to complicate matters just a little bit more, within federal rules, states face several options about which categories of immigrants to cover under which federal benefits. So states can decide a couple things. They can decide whether to provide federally funded TANF and the federally state jointly funded Medicaid to qualified immigrants after the 5-year ban. They can decide whether to provide Medicaid and CHIP benefits to children and parents and pregnant women during their first 5 years as lawfully present immigrants. And they can decide whether to use state funds to provide benefits to qualified immigrants during the federal 5-year ban, or to assist non-qualified immigrants. So states have a lot of flexibility. Most states, and in your states, I know we have people on here from a variety of states, may have done things differently. Most states have opted to provide TANF, Medicaid, and CHIP to qualified immigrants after the 5-year ban. As of July 2009, only North Dakota and Mississippi did not extend TANF to at least some categories of qualified immigrants after the 5-year ban. And as of 2010, only 7 states did not provide Medicaid to most qualified immigrants after the 5-year ban. Several states have also opted to use state funding to provide public benefits to qualified immigrants during the 5-year ban, or to non-qualified immigrants who are ineligible for federally funded benefits. So the resulting federal and state provisions regarding immigrants' access to health and human services, have created this patchwork of complicated and often confusing eligibility rules. And you can see the next couple of slides show state variations in immigration policies with regard to these benefits. And the first one just has the cash assistance of states, and the next one is health coverage to non-qualified immigrants. So you can see, there's no way to keep this all in your head. It's all different depending on what state you live in. because states have some choices in providing benefits to certain groups of immigrants, we're going to cover today just the national rules, the federal guidelines in this webinar. But given that, if you have state-specific questions that you'd like us to answer, we can follow up with you with our resources and with any answers, after the training. So we're going to take a moment now to poll you because we were curious about the clients you serve and if you knew of the immigration statuses of the clients you serve. So I'm going to turn it over to Neil to do that right now. So if you could take a moment to look at your screen and indicate, and we think you can check all that apply, so indicate the children you work with who have the following immigration statuses. So if you work with all of those immigration statuses, check them all. If you work with mostly undocumented, just check undocumented, and we'll give you a couple seconds to answer this, and we're just curious who's on the line. So Terrence says, so we can see the poll, but we can't see the answers yet, just so you know. All right, we'll give you another couple seconds, and then we'll close the poll, and we'll see what your answers are. Okay, great. So looks like 81% of people have answered. That's majority. Why don't we see what the poll results show? Okay, so interesting. So it looks like 86%, the majority of people serve citizens and probably also serve, wow, so a lot of undocumented, a lot of LPRs or green card holders, and slightly less refugee asylees, and a little less than that non-immigrant visas. So that's good. So this will be hopefully really pertain to your audience. Why don't we do the next poll now too, which is more about the parents you work with, and curious if it's any different than the children you work with. We saw a lot of citizen children, so I'm curious if the parents are similarly citizens or if they're more in the undocumented or legal LPR phase. So if you could just do that poll, we'll give you a couple seconds to answer that now. All right. How many people have responded so far, Neil? If you could let us know. Oh, 78%? 82%. Okay. Let's go ahead and show the responses. Okay. Looks like it's about the same or similar. Same amount of citizens and undocumented and LPR. So there's a good variety. All right, great. Thank you very much. That was interesting and good to know. You probably have some mixed status families in there too. So let me just go back one slide. So we're going to now sort of dive back into the eligibility for some of the public programs. So, as you know, as caseworkers and workers in nonprofit organizations, Health and Human Services have a variety of eligibility criteria that must be met by any person seeking benefits or assistance. So programs have different eligibility rules related to income level and family composition, as well as other criteria. For example, for TANF, some work participation criteria. And as we discussed in the previous couple of slides, under some of these public benefits, states have flexibility related to these eligibility criteria. Under SNAP, however, federal criteria apply in every state. So we just wanted to note that, acknowledge that immigrant eligibility rules don't fully describe access to federal benefits for immigrants. We know that immigration-related enforcement activities can affect the broad policy context that determines access to benefits for this population. We want to acknowledge that state implementation and local practices can also affect immigrant participation in benefits programs, as well as the existence of other barriers to access, including immigrants' lack of knowledge about the programs, confusion about the eligibility requirements, language and cultural barriers, family compositions, families where some of the children are U.S. citizens, but one or both parents are not, or one parent lives abroad, one parent lives here, and then also fear of adverse immigration consequences. For example, deportation of a family member who is an unauthorized immigrant. So these are all really important issues that we wanted to acknowledge, but we would need to touch on at a future webinar. So we're going to spend the bulk of the time covering these several major federal state programs intended to support work, economic stability, nutrition, and health for low-income children and families. We'll also mention other benefit programs briefly. And just so you have it, here are the acronyms and the names for all the programs in case it was sort of an alphabet soup for you. I'm going to be talking about the health insurance programs now. So first we'll discuss Medicaid eligibility. Medicaid and CHIP provide free or low-cost health coverage to millions of Americans, including some low-income adults, families and children, pregnant women, seniors, and people with disabilities. Both Medicaid and CHIP are run jointly by the federal and state governments, and details vary somewhat between states. Under PERORA, or the Welfare Reform Act, the following groups may be eligible for Medicaid and CHIP. So qualified immigrants, if you remember who those were, who entered the U.S. before the law was passed in 1996. Qualified immigrants who reached the end of a 5-year waiting period, so green card holders. And qualified immigrants who are exempt from the 5-year waiting period, for example, refugees, asylees, Cuban, Haitian entrants, and others. So of course, even if they're eligible for Medicaid and CHIP, by virtue of their immigration status, they of course have to meet the income requirements for Medicaid too, which are slightly different in each state. So states have some flexibility to expand beyond general Medicaid eligibility. For example, states have the option to cover children and or pregnant women who are lawfully present and otherwise eligible without that 5-year waiting period, and regardless of date of entry into the U.S. 29 states have taken up this option. States can also cover additional immigrants, such as undocumented children, with state-only funds. And that's something, for example, that Illinois does in its All Kids program. Then there's emergency Medicaid. So emergency Medicaid is defined as limited services related to an emergency medical condition, such as the absence of immediate medical attention, which would result in placing the patient's health in serious jeopardy, or serious impairment to bodily functions, or dysfunction of any bodily organ or part. And this is actually a definition in the U.S. Code. But emergency Medicaid is available to all people who meet all the other state Medicaid eligibility requirements except for citizenship or immigration status. So this would include undocumented immigrants, qualified immigrants who are within that 5-year waiting period, and others. We wanted to note that, though, that emergency Medicaid does not cover any long-term care, such as nursing home services or transplants or transplant-related services. It also may not cover long-term therapy, such as dialysis and chemotherapy. And state rules may vary, and some states have state-only funded programs, such as end-stage renal disease programs to cover dialysis. So as I'm sure you all know, the ACA, or Obamacare, passed in 2010, and it changed the picture for some of the immigrants living in the U.S. It opened up more opportunities to get health insurance coverage. The ACA expanded Medicaid in many states as well, but that alone did not change the categories of immigrants who can or cannot qualify. So I'll talk about that a little bit more in the next slide here. So the ACA provided 2 new major cover options: the Medicaid expansion and the marketplace. The ACA gives states the option of expanding Medicaid coverage to any individual with a household income at or below 138% of the federal poverty level, which is a substantially higher income threshold than most states used before the ACA. However, just keep in mind that the same Medicaid eligibility restrictions applied to immigrants after the expansion as applied before the ACA was passed. So non-qualified immigrants remain ineligible for Medicaid or CHIP, except for the states that have elected otherwise. And the 5-year ban remains for most qualified immigrants, except for the chipper option to cover those who are lawfully residing. But the ACA did another important thing. It provided funding for states to create a state-based marketplace or opt into a federal-based marketplace. And the ACA provided new subsidies for coverage targeted to those with incomes between 100 and 400% FPL. Lawfully present immigrants are eligible to receive those subsidies and purchase insurance coverage in the state marketplaces. So that was a large expansion available to millions of immigrants. However, notably, unauthorized or undocumented immigrants are not eligible to purchase coverage in the marketplace, even without a subsidy. And you may know this, but we often get this question is whether someone can choose whether to enroll into the expanded Medicaid program or the marketplace. And the answer is no. Generally, if you're eligible for Medicaid, you can't enroll in the marketplace with financial help in the form of those tax credits. But many lawfully residing immigrants are low income and aren't eligible for Medicaid due to their immigration status. However, they can enroll in the marketplace and buy insurance with financial help. So here's just a nice picture of the eligibility landscape for most immigrants in states that have expanded Medicaid. And there may be folks on the line who live in a state that haven't, but I just wanted to give you a snapshot that if low-income immigrants are eligible for Medicaid because of their low income below 138% of the poverty level, then they would be eligible for Medicaid. But if they're in that 5-year bar, they are eligible for those premium tax credits. So it really does expand options for a lot of LPR families. So here is a long list of immigrants who can enroll into the ACA marketplace. And we got this list from healthcare.gov. You can see the link on the bottom of the page. And actually, healthcare.gov does a great job of showing all the different immigrant categories who can enroll into the ACA marketplace. So I'm not going to read them off to you right now. But just one thing to keep in mind, that includes all qualified immigrants, all LPRs with no waiting periods, you know, people who are already qualified, who would be qualified for Medicaid, except for maybe their higher income. And then it includes a whole host of other people, including people with non-immigrant status, such as people on tourist visas or student visas or others, people with temporary protected status, lawfully, a whole host. I won't go into it. I will note here that the big note that DACA youth, so Deferred Action for Childhood Arrivals, is a subset of immigrants, and you may see some in your work. They are unfortunately not included in the ACA marketplace, so they are considered undocumented and are not eligible for the marketplace. We also wanted to mention briefly that the ACA required states using the federal health insurance marketplace to train navigators to provide outreach and enrollment assistance to individuals seeking insurance in a manner that is culturally and linguistically appropriate to the needs of the population served. So the grants that were given out by the federal government for navigators, you know, were geared towards people who could help speak the language and remove some of the barriers for immigrants applying for health care coverage. We wanted to briefly mention Medicare. We're really not going to go into detail about it because it has a lot of different rules regarding qualifying work history and immigration status restrictions. However, we wanted to mention lawfully present seniors because you may see families with grandparents living in the home or grandparents raising grandchildren. And this is something that wasn't known a lot during open enrollment last year, so we wanted to mention. So in general, if you are eligible for Medicare, you are not eligible for the marketplace. However, some lawfully present immigrants who are over 65 may not be eligible for Medicare, what's called premium-free Medicare, because they lack qualifying work history. So this group of lawfully present seniors are eligible for the Marketplace health plans with premium tax credits. And that's just an important subgroup of a population for you to think about. Now I'm going to turn it over to the other Stephanie to talk about some non-health federal benefits.
Thank you. In the meantime, since Stephanie Becker has been talking, I've been monitoring questions. And I know we don't have a lot of questions yet, so feel free to type in. We did get one question that the audio was going in and out. Somebody was having some trouble hearing. If you are having any trouble hearing, please type it into the chat box or questions, and then we'll address it and try to either pick up the phone or move closer to the speaker or not move around. So let us know if that's a problem. So I'm going to talk now about TANF, the Temporary Assistance for Needy Families. And just to reiterate again, which we'll say many times today, these are all complicated. They all have their own rules, and all of the resources that you're going to be given after the webinar in your resource toolkit will be what you can use for your reference. So you don't have to memorize any of this. And in fact, Stephanie and I don't memorize any of this. When somebody comes to us, we check their immigration status, and then we check it against the charts to assess what they're eligible for. So Congress created TANF, or the Temporary Assistance for Needy Families, block grant in order to provide cash through the Personal Responsibility and Work Opportunity Reconciliation Act, PERA, which you've already heard about, in 1996. States have some choices on how to determine eligibility for TANF and for benefits and services, but there are some federal rules that they have to follow. In general, states must use TANF funds to serve needy families with children. A state can set different eligibility limits for different TANF programs or services. For example, it could limit TANF cash assistance to very poor families, and then provide TANF-funded childcare and transportation, but no cash, to working families who have somewhat higher incomes. Some of the different requirements that they must follow include these. Time limits. Time limits are a very important part of TANF. While states can set their own time limit policies, they cannot provide cash assistance from federal TANF funds for longer than 60 months to a certain family, consecutive or not. So it's called sort of 5-year lifetime. This includes any adult recipient. However, states can exceed or go longer than the 60-month time limit for up to 20% of their caseload based on hardship. So they could decide certain hardship requirements and allow 20% of that caseload, for instance, very low income or families with children, to go past the 60 months. Federal law does not impose a time limit on families receiving assistance from TANF if it's funded entirely from state funds. So states can do what they want with their own money. Most states have set these time limits for 5 years on TANF, though the time limits in about 1/3 of the states are actually shorter than 5 years. States generally provide exceptions and exemptions for some groups of families who meet certain criteria, which allows them to receive assistance beyond the time limit, such as homelessness, for instance. Some states continue benefits to the children in the family even after the parent reaches the time limit. Now to think about or talk about immigrant eligibility in regard to TANF. Federal law bars states from using their federal TANF dollars to assist most legal immigrants until they have been in the United States for about 5 years. You've already heard a lot about this 5-year bar or ban. This restriction applies not only to the cash that you get from TANF, but also to TANF-funded work supports and services such as childcare, transportation, and job training. So a very substantial percentage of poor children have non-citizen parents who are not eligible for TANF benefits and services. A state can, however, use their state funds to provide benefits to recent immigrants who, for instance, are qualified but subject to the 5-year bar, but fewer than half of the states do so. The states can also choose whether to assist legal immigrants or qualified immigrants who are not subject to the 5-year bar or have already been in the country for at least 5 years, and almost every state does. So now to talk about SNAP. The Supplemental Nutrition Assistance Program, SNAP, is the program that was formerly known as the Food Stamp Program, and it's the nation's most important anti-hunger program. In 2014, it helped more than 46 million low-income Americans afford a nutritionally adequate diet in typical months. close to 70% of SNAP participants are families with children. More than a quarter are in households with seniors or persons with disabilities. The average SNAP recipient received about $125 a month, which is only $4 a day in 2014. And the SNAP benefit formula is complicated, but it targets more benefits towards very poor households, and households that are closer to the poverty line get less benefits. SNAP eligibility rules and benefits levels are, for the most part, set at the federal level and uniform across the nation. Those states have flexibility to tailor aspects of their program, such as whether they count a car that you have in your household as part of your income, and still qualify for benefits. In most states, households apply in person at an office. For instance, in Illinois, it's called the Department of Human Services offices. Other states may call it the Welfare Office or the Aid Office, though they can also mail or fax in their applications. And most states now have online applications. Applicants, even if they submit an application online or by mail, they must also, for SNAP, participate in an eligibility interview, which is typically in person, but it can be on the phone. They also have to submit lots of documentation, including things that document their identity, their residence in the state, their immigration status, people who are in their household, income, resources, and different expenses that they have during the month. Okay. So we keep saying this is complicated, and now it gets really complicated. The immigration qualifications for SNAP are pretty complicated, and you will want to look these up and not try to memorize them. The Food and Nutrition Act in 2008 limits eligibility for SNAP benefits mainly to U.S. citizens and certain lawfully present non-citizens. So this is the whole qualified immigrant rules. Generally, a non-citizen has to be a qualified immigrant, as we've talked about before, in order to be eligible for SNAP. And non-citizens, like tourists or students, even though they have a legal documentation to be in the United States, are generally not eligible. There are no time limits for how long eligible non-citizens can receive SNAP. Individuals who are eligible based on their immigration status must also satisfy other SNAP eligibility requirements, such as income and resources. So it's a good time to mention, even though Stephanie Becker mentioned it as well, we're talking about the immigration requirements. That's like one door that somebody has to go through to get these benefits, but then their income or their assets have to be low enough to get the benefit as well. To be eligible for SNAP, most non-citizens must be in a qualified immigrant category, and then in order to get the benefits right away, they usually have to meet an additional criteria, which are listed here. If an eligible non-citizen meets one of the above conditions, then he or she is eligible for SNAP without any waiting period. For example, if we have a legal permanent resident who's a child, they have a green card, and they're under 18, they can get SNAP right away. They don't have to wait 5 years in order to get it. There are some categories of non-citizens who, in addition to the children I mentioned, are also eligible for SNAP, and they don't have to wait the 5 years either. And these are listed here. This chart describes those who are eligible without a waiting period. I think the easiest way to kind of determine this is to use a flow chart. So the last 3 slides are basically summed up in this flow chart. And so I'm going to go through it with you right now just to give you a picture of it. And some of the resources we give you will help you as well if you're looking up a certain person. So the first question is whether someone is a United States citizen, American Indian born in Canada, or some of these less likely groups. If so, and they say yes, then that person is potentially eligible for SNAP. But remember, they also have to have low enough income and assets. If they're not a U.S. citizen, the next question is whether they're a qualified alien. Alien is the term that was prior to this kind of newer set of regulations used for non-citizen or immigrant, but they all mean the same thing. If the person is not qualified, they're not eligible. Okay, so that would be like somebody undocumented. If they are a qualified immigrant, the next question is, and the next 3 questions are trying to determine, do they have to wait 5 years? So the next question is, are you a Cuban Asian entrant, refugee, victim of severe form of trafficking? If you meet any of those, yes, you're potentially eligible right now. You don't have to wait 5 years. If no, it asks, were you lawfully residing in the United States before 1996, or are you disabled, under 18, which I mentioned before, a child, or in the military? If yes, you're potentially eligible. And then finally is the last category, which is basically people who have to meet the 5 years. It says, have you lived in the U.S. in a qualified status for 5 years, or are you a legal permanent resident adult and you've already had 40 qualifying work quarters? And if yes, then you're eligible. So that's a kind of easier way, at least for me. Nothing's easy in this, but it's an easier way, at least for me, to determine if someone might be eligible for SNAP. There are many non-citizens who are not eligible to get SNAP at all, though. And so I just want to bring up a few of them just to go over that. Most non-citizens who are lawfully present in the United States in a non-qualified status, such as students, H-1B visa workers, are not eligible for SNAP benefits. So just like Stephanie had said before, there are people who are documented and they have lawfully residing status in the United States, but they're not eligible for these public benefits. And it doesn't matter if they've been here 1 year or 5 years, they're not eligible. Undocumented non-citizens, for example, individuals who entered the country as temporary residents, like a tourist, and then overstayed their visa, or even entered without a visa, are not eligible. However, it's very important to note that if there is a household member who is not eligible because of immigration status, it doesn't mean that all of the household members will be ineligible. State agencies still must determine eligibility for SNAP for any remaining household members who seek assistance. So if the children are eligible for SNAP just because their parents are undocumented, the state must accept an application and determine eligibility for the children. The state may not deny an entire household just because a non-citizen member is not eligible due to his or her immigration status. The state agency must determine eligibility and benefit level of the remaining household members. And under no circumstances may a state agency require information about citizenship or immigration status of anyone who's not applying for SNAP, so an undocumented parent, for instance, deny SNAP to applying household members just because a non-applicant household member, like the parent, has not disclosed his or her citizenship, immigration, or social security number, or try to verify immigration status through any of the means that are anything other than the means that are provided by federal law. So the way this would work is in a family who has a citizen child or a qualifying child and undocumented parents, and they apply, the state can ask the parents about their income, but they can't ask the parents about their immigration status because the parent's not applying for benefits. The parent's not eligible for benefits, and they can't ask them for a social security number. So now that was SNAP and TANF, and we were also asked to touch on some of the requirements for housing and immigration and employment. So and childcare. So I'm gonna keep going, and then we'll give you a chance for questions. Housing choice vouchers. This is kind of the main types of federal housing assistance. Housing choice vouchers are issued by public housing authorities, and they allow eligible households to rent apartments or homes from private landlords. Section 8 housing are apartments owned by private landlords who receive subsidies from the Housing and Urban Development Agency, which is called HUD, on behalf of eligible tenants. And then there's public housing that's owned actually by public housing authorities. Usually people have to pay about 30% of their income to rent any of these types of housing and receive the assistance. Generally, in order to receive the housing assistance, a tenant or a member of their family must meet the immigration statuses. So you get the picture that this is a pattern, right? You have to be a qualified immigrant. Very importantly for housing assistance, if one member of your family fits into any of those categories listed, your whole family can apply for housing. The person doesn't have to, who meets the requirements, does not have to be the head of household. It doesn't have to be a parent. It could be a child. It could be a 1-year-old child. And only the person who's eligible must provide the social security number. So for example, if a child in the family is a U.S. citizen, the whole family can apply to live in a rent-reduced apartment, which is very beneficial. HUD-funded programs provide emergency shelter and transitional housing if someone is homeless, and that's available to all immigrants regardless of status, so we wanted to let you know that. Only the household members who claim to be a U.S. citizen or eligible immigrant have to verify a valid social security number. So again, you should not have to give your social security number if you're not an applicant. And in fact, we always warn our clients, make sure you don't, in case an application asks for a Social Security number, don't use one that's false or something that somebody else gave you if you don't have to provide it. So a lot of people ask us, well, how do they figure out rent if two people in the family are undocumented non-citizens and the child is a U.S. citizen? If everyone in the family is a U.S. citizen or eligible immigrant, then they all pay reduced rent, which I mentioned is about 30% of their household income. However, if at least one person in the family is not a citizen or eligible immigrant, then the rent will be higher because the amount is prorated. So only the qualified immigrants get the discounted rent. So for instance, the rent's only discounted in the example I gave for the infant who is a U.S. citizen, not for the parents. And importantly, and this is really important for families with undocumented parents, if no one is left in the household who's a citizen or eligible immigrant because the last person who was eligible has left the household, such as when a child goes off to college, then the assistance will be cut off and the family will have a deadline to leave the housing program. And so that's really important for families with undocumented or ineligible parents, but children who are eligible, because the whole housing assistance might be sort of resting on that child. Now to talk a little bit about childcare assistance programs. Most childcare assistance is funded through something called the Childcare and Development Block Grant, CCDBG. Lots of alphabet soup here. And TANF also has a block grant that helps with childcare assistance. They have different rules. Of course they do, right? They have different rules regarding immigrant eligibility. They're both defined as federal public benefits. So providers of childcare assistance might be required to verify immigration and citizenship status of the potential recipient based on these guidelines. All programs that receive federal funds are required to comply with the Civil Rights Act, which prohibits agencies that receive federal financial assistance from discriminating based on language, ethnicity, and other categories. So let's look at the childcare programs funded under CCDBG first, because it's more expansive. The federal guidance states that for implementing the verification requirements mandated by PRORA, only citizenship and immigration status of the child, who is the primary beneficiary of this child care benefit, is relevant. So it doesn't matter if the parents are undocumented. And this was a question we got prior to the webinar. The child is still eligible for child care assistance. The state can only consider the child's immigration and citizenship status, not the parents, when verifying eligibility for these subsidies. And the child should be eligible if they're qualified. Now turning to TANF, which is different. So TANF, including TANF-funded childcare, which is a part of the TANF program, is generally denied to legal immigrants during their first 5 years in the United States, as we discussed before. There are limited exceptions. But many states will use state funds, their own state funds, or the previously mentioned CCDBG funds, which is a different kind of funding, to cover immigrants during the 5-year period. In a mixed status household, where there is at least one citizen and one non-citizen family member, a citizen child might be eligible for federally funded TANF cash assistance, as we mentioned before, even if the parents and other family members are not. In most states, however, TANF-funded childcare is considered as serving the needs of the parent and therefore not available to an unqualified immigrant parent. So the thing is that CCDBG, those funds consider the benefit of childcare assistance going to the child. So if the child's a citizen and the parent's undocumented, it's fine, they can get the assistance. But TANF-funded childcare doesn't work that way. It's considered to be a benefit for the parent, and not the child. It's not logical, but that's the way it is. And so then the parent, if the state's using those kinds of funds, may not be eligible, and therefore the child doesn't get it either. Verification requirements do not apply to children who are receiving Head Start services, like Head Start or Early Head Start, because that's not considered a federal public benefit. So we wanted to mention that because we got a question on that. Any child who's eligible for Head Start can enroll without any regard to immigration status or citizenship, so the child could be undocumented. And hopefully that you also know that verification requirements do not apply to children who receive public and private pre-kindergarten services or public and private child care, because those come under the Supreme Court ruling that all children living in the United States are entitled to access public education. Again, states also are not permitted to require Social Security numbers for the receipt of childcare assistance for the child and may not deny assistance to applicants on the basis of a refusal to provide a Social Security number. And just to review on all of these situations in which an undocumented parent or parents who are not qualified apply for benefits for their children or qualified children, parents may apply for them. Their income might be counted in determining if the child is eligible for benefit, even though the parent themselves is not eligible. Usually the program considers the benefit for the child, so they consider the benefit to be for the child, with the exceptions that we mentioned, like TANF childcare. And generally, a Social Security number is not required, and parents should be educated, and you can help educate parents about this, so that they know that even though there may be a box on the application that asks for their Social Security number, and we see this a lot, if they don't have one, they should not put one in, especially if they might be using a Social Security number that's not their own or not valid. Phew. So now we're going to take a break for questions, and it looks like questions have been coming in. So we're going to answer some of your questions now if we can, and then we're going to go on and give you another question period afterwards. Don't worry if we didn't answer your question right now. It may be something that we know we're going to get to later, and it might be something that we have to look up, so we'll have to answer later.
Well, here's one question that someone asked and then said that it was answered anyway, but I thought it was a really good question, so yeah. I thought it's worth reading aloud.
Yeah, so one of the questions is, can families apply for TANF benefits using the U.S.-born child under 18? So by using the word using, it means that the U.S.-born citizen child is really the one applying. So the answer is yes, that TANF benefit would, the cash benefit, would be basically seen as for the benefit of that child, and the parent, even if they're undocumented, can absolutely apply for that cash benefit for the child. The exception would be that childcare assistance, because the childcare assistance that's provided under TANF, for whatever reason, that's considered to be a benefit for the parent, I guess, because they're working. And so if the parent's not eligible, they don't get it. But like I said, most states use some other funding to do that. So usually childcare assistance may be available. Other question?
Yeah, so the other question is, does having an ITIN qualify the family? And that's an individual taxpayer identification number. And and then I clarified with the asker for which public benefit, because I believe it could be different for different public benefits. And specifically the questioner asked for housing benefits. That's something we might have to look up for you. I can tell you that for healthcare, for access to the marketplace and Medicaid, an ITIN does not qualify, is not a substitute for a Social Security number. So a lot of undocumented workers have ITINs and they pay taxes in the U.S., and we know that. However, having an ITIN does not give anyone any immigration status or eligibility for any programs. I would imagine it's the same for the housing, but I want to double check with our housing experts to ask. The next question is, this is when you were talking about what if someone doesn't have a Social Security number? And the question asks, some providers will not accept an application if the head of household does not have a Social Security number. How do we handle this?
So we're going to give you some tips to handle, and we'll go through it. And I know we're already running behind, so we will talk about that a little bit. It is difficult because people are asked for Social Security numbers in circumstances where legally they should not be asked for it. You know, we're going to give you references to legal services organizations and immigration service organizations in your states that you could refer somebody to. In general, I tell people to start with, if they feel empowered enough to say it, that they are not an applicant. They are not applying for themselves. They're not applying for anything for themselves. They're just applying for instance, their child. So their child's Social Security number is the one to put in there. But we can talk about that more later. So I think we're going to move on, and we'll continue to monitor time and try to get through all the slides and your questions.
Yeah, but those are some really good questions, so thank you for those. And so we know that you all wanted to have some specific resources for undocumented clients. And so we have a couple slides on that for you now. So first we wanted to start with some health resources that undocumented persons can access. So we already talked about emergency Medicaid, which is available to anyone regardless of immigration status, and then also Medicaid for children and pregnant women. So some states pay for children up to age 18 or 19 or pregnant women regardless of their immigration status. However, across the country, these are the following resources that are available to undocumented people. Healthcare at community health centers, such as federally qualified health centers. This is a really big place for undocumented families or individuals to have a medical home. And in fact, we have a resource here in Illinois where people can look up by zip code, where the FQHCs are near them. So if someone can't sign up for Medicaid in the marketplace, they can at least refer someone out to a community health center near them where they can get the primary care and preventive care they need. In that same boat are public health programs like state or local public health departments. Also, private insurance outside the Affordable Care Act marketplace is available. They do not typically ask about immigration status. Of course, you don't get the financial help and through the form of a tax credit, but you could pay full price in private insurance outside the marketplace, or of course through an employer. And then also all programs using any federally healthcare block grants, such as mental health, maternal and child health programs, family planning, communicable diseases, and immunizations are all available to undocumented people. And then all programs providing health services necessary to protect life or safety, emergency medical, food or shelter, some domestic violence services, crime victim assistance, and disaster relief. And then, of course, undocumented people are eligible for hospital financial assistance programs, or sometimes it's called charity care, depending on where you live. Here's a long list of other types of benefits that undocumented persons can access. So Stephanie was already talking about SNAP, but also school breakfast and lunch programs remain open to all children regardless of immigration status. And every state has opted to provide access to the special Supplemental Nutrition Program for Women, Infants, and Children, or WIC. And also short-term non-cash emergency disaster assistance remains available without regard to someone's immigration status. So also exempted from the restriction are other in-kind services necessary to protect life or safety, as long as no individual or household income qualification is required. And in 2001, the U.S. Attorney General published a report, or a final order, specifying the types of benefits that meet these criteria. They include child and adult protective services, programs addressing weather emergencies and homelessness, shelters, soup kitchens, Meals on Wheels, mental health services, a variety of services, safety net services that are available to everyone in a community. And again, if you feel like someone is being turned away for these services due to the immigration status, that is something we can help refer you to a legal aid organization in your state. Mixed status families. So we already talked about this throughout, and what it means is that members in the family have different immigration and citizenship statuses. So for example, some families may have tax-paying members who can't buy health insurance through the marketplace alongside other family members who are eligible to use the marketplace as citizens or LPRs. In other mixed status families, some members may not be eligible for the full Medicaid coverage, while other members are eligible only for Medicaid or CHIP, but as soon as they age out, they're not eligible anymore. So we just want to make sure you knew that mixed status families can apply for premium tax credits in the marketplace for their dependent family members who are eligible for coverage. So this gets to the non-applicant versus the applicant issue. If someone is undocumented, they can apply for Medicaid and CHIP coverage for their dependent family members. Family members who aren't applying for health coverage for themselves won't be asked if they have eligible, or shouldn't be asked, if they have eligible immigration status. In addition, U.S. citizen or legal immigrant children of undocumented parents should have the same access to health insurance and health services as all other children. And on the marketplace, there's something called child-only plans, where someone who's undocumented can buy a child-only plan for their child if they themselves aren't eligible on the marketplace. So if you're working with undocumented clients, you can assure them that there are protections in place for non-applicants, and this is something we just talked about, who aren't applying for public benefits for themselves. For example, federal and state marketplaces and state Medicaid and CHIP agencies can't require applicants to provide information about the citizenship or immigration status of any family or household members who aren't applying for coverage. States also can't deny benefits to an applicant because a family or household member who isn't applying hasn't disclosed his or her citizenship or immigration status. Information provided by applicants or beneficiaries won't be used for immigration enforcement purposes. And in fact, the ICE passed out a memo last year specifically stating that immigration would not be used, there would be no sharing with Homeland Security about when applying for the marketplace. However, we did want to mention that if someone does have a Social Security number, it may increase the likelihood that that application information can be verified electronically through a system that Stephanie is going to talk about. People who are not eligible for Social Security numbers may use, as we talked about, the ITINs, the individual taxpayer identification numbers, to file taxes. However, they have no place on an application for marketplace tax credits or Medicaid. So now this is about the requests for Social Security numbers for applicants, for Medicaid and the ACA marketplace applicants, which is different than non-applicants. So for Medicaid and CHIP, Social Security numbers are generally required of Medicaid applicants. However, coverage cannot be denied or delayed pending issuance or verification of a Social Security number. Also, Medicaid agencies must help individuals apply for a Social Security number if they are eligible and don't have one, or if they don't know their Social Security number. So some Medicaid applicants do not have to provide Social Security numbers, including newborns who are in the process of obtaining one, people who have religious objections, or certain lawfully present immigrants who are not eligible for a Social Security number, or can only get one for a non-work purpose, such as certain domestic violence survivors. And just to note, for ACA marketplace private plan coverage, only applicants who have a Social Security number are required to provide one. Now I wanted to talk a little bit about the issue of public charge. So many immigrants may be deterred from applying for public benefits because they don't want to be what has become termed a public charge. So a public charge is an individual who is likely to become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance, or institutionalization, that's a big word, for long-term care at a government expense. So for benefits that are looked at by the immigration agency, whether a person is likely to become a public charge is usually considered when someone is trying to become a permanent resident or get a green card. It's also considered when someone applies for certain non-immigrant or other temporary benefits, for example, by extending non-immigrant status within the U.S. So a number of factors must be considered when making a determination that a person is likely to become a public charge. Not all publicly funded benefits are relevant at all to deciding whether someone is likely to become a public charge. So we want to go over those now. So first, what benefits could be considered in determining public charge? And here's a list. Cash assistance for income maintenance and institutionalization for long-term care, that could be considered. SSI, the receipt of SSI or Supplemental Security Income, TANF cash assistance, state and local cash assistance, and all of these could be considered when determining public charge. And we don't say it on the slide, but I think if someone, an immigrant, is concerned about this, they should consult an immigration attorney about whether or not to get a benefit if they are worried that it would impact their ability to become, for example, a legal permanent resident. But importantly, there are lots of benefits that are not considered in determining public charge. The receipt of Medicaid and other health insurance and health services that we talked about in the last couple of slides, that is not considered. Nutrition programs that the other Stephanie was talking about, so food stamps and WIC is not considered. Housing benefits, childcare services, energy assistance. So all of these are really important benefits that someone should not have to worry about receiving if they would like to stay here long term and become a LPR or citizen eventually.
So I'm going to now talk about the process of applying for public benefits. And we do have a lot of material to cover, and we may not be able to get through it all. But we will go through pretty quickly, and we're also monitoring the question box. So we've addressed all the questions that you've typed in so far, but please do continue to type in. I see a few more have come in all of a sudden. So we will try to address those as soon as we can. And I will talk for about 12 more minutes and make sure to leave at least 10 minutes to answer as many questions as we can, because we see that you're loading in your questions quickly. So real quickly, the SAVE, I won't even go into exactly what the SAVE program does, but it's a web-based verification of immigration status. And as Stephanie said, the information that they use to verify cannot be sent to Department of Homeland Security. So it can't hurt anybody's immigration status itself. This slide just provides a little explanation of how it works after you submit your documents to the public agency and how they go ahead and verify it. And usually they can verify it by computer. If not, they will ask you for more documents if they need them. In terms of applying for public benefits, it differs in every state. Typically, you're going to apply through the local state agency office or online. And when a benefit starts depends on the process for it. Usually TANF begins 30 days after the application, with SNAP starting right away on the date of application, and Medicaid is the only program that can go backwards. So if you're eligible back 3 months, it can cover medical bills. And this just gives you some idea of some of the things that people should provide when they're applying for benefits. Most public benefits get authorized only for a limited period of time, so they don't go on forever. And typically you go through a renewal or redetermination process. It's shorter for SNAP or TANF every 6 months, and usually for Medicaid every 12 months. And you usually have to report life changes. And we'll give you resources in the resource repository all about redeterminations and renewals. We also just wanted to quickly mention that sometimes a decision's made that the person doesn't agree with. So they might be told that their SNAP application is denied, or they didn't provide the immigration requirements they were supposed to, and they can appeal those decisions. It's important to tell people that they should open their mail. You probably already know that. And that they should check the deadlines for appeals, because those deadlines can't be passed, so they need to look at that quickly. And we're also going to give you some information about legal resources for people to appeal. So I'm going to quickly talk a little bit about employment authorization, because we were asked to address that. But I'm going to go through it very quickly because it's also complex. And we're giving you really information here and in the resource manual on the rules, kind of what employers can and cannot do. And in general, they can't discriminate against people who have immigration status or non-citizen status. The federal law requires that employers fill out these special forms for everybody called an I-9 Employment Eligibility Verification Form. And there's lots of things they can ask or not ask in terms of that process. And so we're going to go through a little bit of that. Employers definitely can ask in order to give someone a job for their employment authorization, but they cannot discriminate in any way based on a person not being able to either submit that or based on their national origin. They can't engage in any unfair practices related to requesting or reviewing workers' documents. Everybody needs to be treated the same in terms of asking for this kind of documentation. For instance, we all have to give I-9 information, whether you're a citizen, a non-citizen, or you have a work authorization. That process is verified, just like the SAVE process was an online process. This is a verification process that's used for work authorization. If somebody feels that they've been discriminated against or asked for information they shouldn't have, they can file a claim, they can file a complaint, and they can do that with OSC, which I put right here, or with the EEOC. And we'll give more resources on that, but this is how they file a complaint, or they can call the free toll-free hotline. Undocumented workers can still call the OSC to report an employer that they believe is violating discrimination laws, although they can't file an actual charge, but they might be referred to another agency or get some helpful information. So we did want to include this because undocumented workers can also use this toll-free number. And they don't even have to identify themselves. They can be completely confidential. They can just report that an employer is doing something that they think is wrong. So we've included in here some tips to protect their rights, and that's something that you can actually give to a client. They always should keep copies of everything, get the names of anyone that they can get the names of, even take a picture of a job announcement if it says only English is required or only U.S. citizens can apply. They could even take down the flyer and keep it or keep copies of it. The one thing they might want to be careful about not doing is recording something someone says on the phone, because lots of states have laws against recording someone without their permission. So this gives more tips of just how to keep records, the types of things that they can keep to document. And I'm moving through this very quickly because I know we have a lot of questions, so I'm going to move through these quickly. But we will give you a lot more information, as it says right here, on employer audits and employer information in the toolkit. That gets us quickly to our resources and referrals. And I think I'm actually going to change it up a little bit and maybe take some questions right now, and because then I'll show you the resources and referrals if we have time for that, because I want to make sure that we have enough time for some of your questions. Is that okay, Stephanie?
Yeah, that's great.
Okay.
So I'll start reading them,
Okay.
and we can decide if we can answer them or not right away. So this is just a clarification about Head Start. So the question is, children cannot be turned away from Head Start regardless of immigration status?
That's correct. Children are eligible for Head Start and cannot be turned away from it regardless of their immigration status.
Okay, great. So this question, parents who are here undocumented, can they apply for assistance for the children? Can that affect the parents later if they want to apply for residency? And I'm not sure exactly which assistance it's for, whether it's healthcare or childcare.
But in general, it cannot affect their, it will not affect their later application for, to change their status. By residency, you don't mean state residency, but you mean immigration status, because the child themselves is eligible and the child themselves is the one getting the benefit. So if the child's a citizen and you're getting TANF for the child, like a child-only grant or Medicaid for the child, that benefit inures to the child, and it doesn't impact the parent's later immigration status for themselves. Nor should it impact the child either, because the child themselves is eligible for it. Very, very minor exceptions to that. If the child were to receive long-term care in a nursing home, it could possibly affect the child's immigration status. But it's very, very rare. The fear out there is a lot greater than when it, than the reality.
All right, this is a question about Section 8 housing, so we may or may not be able to answer this, but it's an interesting question. So I'm confused how a newborn applies for Section 8 housing and how rent is determined. My current Section 8 application requires all Social Security cards and all birth certificates for the whole family.
Okay, so that, my understanding is only one person, like I said, needs to be eligible for that, and only one person in the family has to have a Social Security number and apply. Now, the rent would only be prorated for that one person, so the rent could be too high otherwise. So if you have 5 people in the family who are undocumented and one person, then only the one person part of the rent would be split by 5, and then only that one person's rent would be low. So it could be that it's just too high. On the other issue that you're being asked by your housing authority to provide that I'm not sure. And so we're going to follow up. We can see who answered the question. We're going to follow up with you and find out what state you're from, exactly what the application looks like, and we're going to refer to our housing experts and get back to you on that.
This is a question, that I'm not sure we can answer, but it's a good question. So can undocumented non-citizens be served with federal dollars in the workforce development system? For example, have a credentialed program paid for through funds through WIA or Workforce Investment Program. So
through WIA? Yeah, I don't know the answer to that, so we're going to flag that. I'm glad we said out loud so everyone knows. We're going to look into the work incentive, and we will be sure to answer that in the FAQs.
A clarification, did you say that emergency medical assistance doesn't cover dialysis?
We're actually dealing with that right now in our own state. So emergency medical coverage to non-citizens, so that can go to anyone who's not qualified for Medicaid, like undocumented, has been narrowed a lot in the last several years. For instance, long-term care is not covered. Transplants are not covered. It's been narrowed, the definition. Different states do it in different ways, but they have to with the federal law, they have to abide by providing something that's short in duration and of emergency, such as having a baby, being in a car accident, you know, entering the emergency room. End-stage renal disease and dialysis has typically been covered, especially if it's provided in a hospital. Our state right now is going through whether they, trying to figure out whether they can cut it if it's provided in an outpatient dialysis center. So it could be a little state by state depending on what your state's doing. And please do type back in what state you're from and if that state is saying that they won't cover dialysis services. But I will answer that in the written FAQs and also give you some of the federal law on that. So dialysis should be covered for people in end-stage renal disease who are undocumented if provided in a hospital. The outpatient dialysis could be a different situation.
When does the 5-year bar officially start for immigrants? How do you prove that an individual has been here for 5 years for both qualified and non-qualified or undocumented or aliens? For both qualified and aliens. So how do you prove that you're 5? So you do receive, you would receive some sort of documentation, either a passport or a stamp on your passport from the immigration agency, and that's when your official date for that 5-year bar starts. I think if you, again, we can respond directly to the person who asked, but if there's a specific question about someone maybe where it was unclear, then we could kind of give you some guidance on a case-by-case basis.
Yeah, and I have to look back at the federal law, and you know, this stuff is so complicated. You can see we don't know it right off the top of our heads, and sometimes have to look it up. I believe that, so let's say you came in as a tourist, and then you, because you had a U.S. citizen relative, you were able to apply for a green card and then get your legal permanent residence status. I think your 5-year bar doesn't start until the start of your green card process, because I know that a couple states count it back to the date of actual like entry as a tourist, and I don't think that's actually the federal law. So we will, and that's why I'm glad you're typing this in, we will clarify that exactly, but I believe it starts with the date that you meet your qualified status. So we'll make sure to clarify that.
This question was about what is available to undocumented people in terms of their health insurance. And I had mentioned that private health insurance sort of off the marketplace or employer insurance was available. And the person asked that she thought private insurance was illegal now, or is that on a state-by-state case as well? And it's confusing. So it's not illegal to have a plan off the marketplace. So people can buy, for example, a Blue Cross Blue Shield plan. What has changed, what the ACA has changed, and it is a little different in each state. I will tell you in Illinois and in most states that, for example, here, you know, open enrollment is open enrollment, regardless if you're off the marketplace or if you're a private plan off the marketplace or on the marketplace. So at this point, if I were to go try to buy a plan, it wouldn't be illegal. I could buy one, but it wouldn't prevent me from being penalized from the individual mandate. So it would be not considered what's called minimum essential coverage. So I could buy it and it could be short-term coverage, but when I go to say on my taxes whether or not I have health coverage, I can't say that I have a qualified ACA or Affordable Care Act plan. And that is the change in terms of the private health insurance market. However, during open enrollment, so before February 15th of this year, someone, an undocumented person, could have gone on just directly to an insurance carrier and bought a plan directly from them.
And that would have met.
And that would have met it, yeah. Let's see.
We have a lot of questions here, so we're reading through them. And again, if we don't get to them, we will be responding in the written FAQs and by email if it's very specific or we need more information. Is the ban on information only to prevent deportation, or does it protect against sharing the information for purposes of applying for citizenship? So I think you're referring to because we said that information that goes into Medicaid or CHIP or Marketplace can't be shared with immigration. And yeah, it can't be shared with any agency, Homeland Security or immigration, for any purpose, for deportation or applying for citizenship. That's right, yeah. Okay, there was more comments. Okay, so it looks like some comments. Again, keep typing your questions. I just want to show you, I'm not going to go through all of this since clearly we our webinar ends soon, but we've given you some practices some information that you can use and promising practices that have worked in other states to increase access to benefits. So kind of overcoming, language and literacy and transportation, and those issues are obviously huge. Addressing mixed status families' application challenges are very important, and some states have actually worked to make the application streamlined, so it's all together, but sometimes that actually hurts mixed families who want to apply for different benefits or maybe eligible for different benefits. This is more the kind of policy issues, and we'll post resources in the resource manual on that if you work more on a policy front, on changing policies in your state to make it more friendly for non-citizens. We want to point out and give you some information on discrimination and let you know that both, Title VI of the Civil Rights Act and the ACA, Affordable Care Act, all have prohibition on discrimination based on race and ethnicity and national origin. But the other thing is the prohibition extends to applications, processes, and procedures that have a chilling effect. So anything that would even deter eligible applicants from applying might violate it. An example might be, and I think you guys have brought this up today, if an agency asks, for instance, a person who is not applying for benefits, like the parent who's just applying for Medicaid for their child, to fill out a section on their national origin. This is unnecessary information, and it could actually scare a parent into not applying. So let's say there's a part on the application, what's your national origin? A parent might not even apply because they're scared to even check that off. So that can't be a required question. Let's say a state wants to gather data. Like I know our state has a national origin question on the application just for data purposes. But they put in big, bold letters, you do not have to, this is your own option if you want to check it off. But that question, if it looked like it was required, could possibly even be considered having a chilling effect. This gives you some information on access to language services and how you could actually file a complaint if a hospital or another federal agency was not providing interpretation services, which we can also follow up with more information for you. And some tips, really good tips from Georgetown Center for Children and Families on talking about immigration status with your clients. And I suspect this is stuff that you guys already have a lot of information about and actually could probably help us and give us some tips. So we just kind of put those out there for discussion. And then lastly, we just want to let you know that before we answer a few more questions that, as we keep saying, there will be a resources toolkit that will be made available to you, a recording of this webinar, written FAQs where we can answer more of your questions, and more detailed information. So I think we have time for a few more questions.
One question, and Stephanie, maybe you remember this. I feel like I should, but I don't, about you visa recipients. So the question is, and I might have to, I know the answer somewhere, but I don't have it at the tip of my tongue. Are you visa recipients qualifying immigrants? And if so, do they have to wait the 5-year period to qualify for benefits?
I have the handy-dandy chart with me, but I think they don't.
I think they don't either.
Yeah, they're usually not eligible. And one of the charts we're going to give you is the National Immigration Law Center has a chart where you can look up every single program and every single qualifying immigration to see if they're eligible. But generally, the U visa holders are not eligible. And I don't know which benefit is that. Are they asking for?
Actually, I don't.
Because they are eligible for the ACA market.
Right, for the marketplace.
Marketplace is probably the only one.
But she just want to know if they are qualified, technically qualified immigrants. So it doesn't specify the public benefits. Why don't we get back to you about that?
Yeah, so we think it's no, but we will we will answer that in writing for sure.
And any other questions that you guys want to?
Yeah, we have 3 more minutes, so please do type in other questions.
I know we want to, maybe 2 more if we want to turn it back over to Rob.
Yeah, 2 more questions. Okay, it looks like, and if we didn't get to your questions, either because we don't know the answer to it, or we want to ensure, and sometimes it's hard on a webinar where we're thinking while we're talking, so we don't want to give you wrong information, which is why we like to do written FAQs afterwards. But we have your email from your registration, so we can also email you if we need more information. And I am going to, and also in the resources toolkit we'll answer that. And in that resources toolkit, you will also have the overview of immigrant eligibility for every federal program, so you can look it up as well. And then lastly, for state-specific information, I know that you live in different states, and so we will give you more. There's an entire sort of chart where you can look up your state and how your state may have made choices in some of these things where we said that states have different choices. So we're going to turn it back to Rob now to close out, and hopefully we will keep the relationship going with all of you into cyberspace. So Rob?
Thank you very much. I want to, first of all, thank both Stephanie for a job well done. I appreciate how you went through the information. A lot of material, as we said up front, but the detail that you're able to provide and taking questions throughout, I think, was fantastic. So thank you for that. I wanted to also thank Rick Carrick, who partnered with Stephanie to organize this. We referenced several times about the toolkit. It will be available through the SIF's Resource Center. So we will make sure that we can pass that out to everybody. The YouTube portion of the webinar, it's going to be out on the Shriver Center. It's going to be open to the public, so when we get that link and everything else available, we'll make sure we pass it on. And that specifically you could pass on to whomever else, because it is open to the public. You know, one of the things that's been most important for me over the past 4 years of working with the Institute is to be able to provide a value add to our partner communities and the service providers. And hopefully, Rick and I and Raleigh heard you and understand that this is a topic that would be of benefit to you. So we look to do different topics throughout the year. Thank you again for participating. You will receive a follow-up survey, so please provide feedback, and that will allow us to continue to modify and enhance things as we move forward. So the close of this, everybody have a fantastic day. Thank you again, Stephanie and Rick, and we look forward to talking to you soon. Bye-bye, everybody.
Thank you, everyone.
Thank
you.